Everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluates. As a bit of background, we at Digital Law are a niche law firm specialising in working solely in technology and cybersecurity law sector. In each episode, we look at the recent stories in the news relating to digital technology around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we're covering this week, check the links in our show notes. And by way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and joined by Peter Wright. And after Peter's introduced himself, we will dive right into the stories for today.
Thank you, Amelia. My name is Peter. I'm a solicitor and the managing director at Digital Law. And we've got an interesting range of stories, quite a few international ones for you on this episode. Some that are, I think, just generally interesting. Others are, I think, potentially quite relevant to the businesses that some of our listeners and certainly the sort of things that some of our clients will be letting them know about this.
Definitely.
So I will pass back to Amelia to start taking us through.
Thanks, Peter. So just going through the stories one by one quickly, we've got the Uber fine, and they've been fined 290 million euros. We've got Pavel Durov, the founder of Telegram, who is under investigation and has been charged. We've got the Australian right to disconnect, ICO action against the Labour Party, software providers provisional fine after an NHS ransomware attack, and prisoners' mobile phone access. So before we dive into these stories, here's some background information on our podcast producer, Anson Evaluates. So Anson Evaluates are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialising in advising clients over multiple jurisdictions. So diving into our stories for today, and we're going to kick off with the Uber fine. So the ride-hailing app Uber has been hit with a 290 million euro fine, so that's around £246 million, for transferring the personal data of European drivers to US servers in violation of EU rules. And this is coming from the Dutch Data Protection Regulator. So the Dutch Data Protection Authority, so the DPA, said that the transfers were a serious violation of the EU's General Data Protection Regulation, so GDPR, as they fail to appropriately protect driver information. And so that information includes ID documents, taxi licenses, and location data. And all of this was transferred to the company's headquarters in the US over a 2-year period. So I will just flag here before I pass over to Peter that Uber said that it will be appealing the fine, which it called unjustified. So while data transfers to the US are allowed under EU law, there is significant uncertainty around whether they can occur without any further authorization. So Peter, what's your thoughts on this?
So this is an interesting one in that, first of all, I think the size of the fine. So it's up there with the sorts of hundreds of millions of euro fines that have been handed out to Meta and which includes WhatsApp and Facebook, that have been on the receiving end of enforcement, as well as Amazon has been on the end of significant fines when it comes to GDPR enforcement. So it's a significant one, being in the sort of the bracket of the hundreds of millions. The second thing I'd say is that this was a piece of pan-European enforcement, in that the complaints apparently were originally made to the French regulator. But under the one-stop shop principle, it's ended up being the Dutch regulator, which is where Uber's HQ is located, that has ended up handling the enforcement under the principle of the sort of one-stop shop. If you're a multinational company, offices and presences in lots of different locations, it's supposed to be you're regulated by the regulator in the jurisdiction where your main decision making takes place. So given that the EU HQ is in the Netherlands, it's the Dutch regulator that's carried out this enforcement. Interestingly, they've tried to argue and say, look, this was the applicable period that we're being fined for here relates to the period when the EU-US Privacy Shield was struck down. So that ran for a period of several years, where it was clear that this thing was not in place. The solution to that, well, the solution, the new system, the new framework was only recently put in place within the last 12 months. So we're looking at that sort of 2020 to 2024 period. And they're saying, look, given that there was no clear mechanism in place for the sharing of data from Europe to the US during this period, then it seems nonsensical that we're being fined for it. So they're already saying, oh, we'll be appealing this fine on that basis. But the point is, they probably already made whatever those excuses are around the lack of a privacy shield or privacy framework. They've probably already made that excuse to the regulator anyway, and they were still fined. So difficult to know what new information they would end up bringing to the table, really.
I think it's quite interesting as well because a few other stories were saying that in a related case, the DPA fined Uber 10 million euros in January this year for infringement of privacy regulations regarding its drivers' personal data. So they have already had a somewhat similar fine before, because again, we're talking about driver personal data. So clearly there is a level of issue here if it's already been identified by the regulator. I think it will be interesting to see, like you said, in terms of that appeal, what new information is brought to light. And I definitely think in terms of certainly our clients thinking further afield, that it will potentially impact the way that they're transferring data, particularly if they are using transfers to the US, and see what sort of precedent this sets if it does go any further than this.
Yeah. And of course, this also comes down to the fact that, okay, whether you've got a privacy shield or anything in place, there are other mechanisms, and it was made quite clear by the European Data Protection Board that once the EU-US Privacy Shield was ruled to be invalid by the Court of Justice of the European Union in 2020, they said, look, you should have standard contractual clauses in place. So any contract from a company to a sub-processor saying you'll be handling personal data, those clauses should have been in place, and they should have been not just in the contract, but you should be able to then use them to say, look, there is an equivalent level of protection in place through the mechanisms that are created through that contract. Or you could have binding corporate rules in place. So if we were looking at moving the data from Uber in the EU to Uber in the US, and you could say, well, it's all within the same company, we'll do it within these binding corporate rules, which would have had to have been signed off by the Dutch regulator. But it looks like those were not in place. Indeed, it looks like Uber is saying we were relying on standard contractual clauses, but they were no longer being used from August of 2021. So that lack of there being any mechanism from August 21 onwards is what seems to have led to the problem. Up until the end of last year, 2023, when Uber says, well, we were then using the successor to the Privacy Shield, which is the new privacy framework.
Which, again, we will flag the fact that I'm sure Max Schrems will end up coming along and kind of trying to pull that down as well, because if you are a regular listener, you will recognise the name Max Schrems, because he generally always has a problem in some way, shape or form, and he does not hesitate to kind of flag the problem to any regulator that will listen.
You say that, but funnily enough, I've almost heard that Schrems has almost said that through boredom and tedium, he's actually wondering if he actually has the energy to go and do this again.
Really?
Yes.
Well, so, maybe the shield or the framework is finally safe then.
I think he's starting to think, do I want to do something else with my life at this point, given that he's been engaged on this since he was an Austrian law student.
Yeah.
And he might decide that, what was a sort of a research project when he was doing his degree, he might actually want to go and do something else. But anyway, we digress. The point is here that actually, on the face of what the decision from the Dutch regulator says, it seems a fairly elementary and clear-cut breach to say that, look, you couldn't rely on the privacy shield, it wasn't there. We did make it quite clear that in the absence of that, you should have one of these other mechanisms in place, and you did not, and therefore you are being fined through the fact that you were therefore exporting data of EU data subjects from Europe to America without the proper mechanism being in place, in this instance, standard contractual clauses. And only Uber can answer in terms of why, from August of 2021, they did not have standard contractual clauses in place. If they did that, and that was either the decision of their own in-house lawyers or they were advised by private practice, that was really bad advice. Certainly we, to very great lengths to make sure all of our clients have the right standard contractual clauses in place, are aware of these issues and are aware of the dangers of transferring data, of EU data subjects outside of Europe. And we always say to them, well, try and use infrastructure and systems in Europe so that you don't have to engage in these sorts of transfers, so that this sort of enforcement doesn't happen.
Precisely.
So as to why the lawyers for Uber weren't making that quite clear, at the moment it's quite murky in terms of why that fairly obvious and basic advice wasn't given. But sometimes what we feel is obvious and basic advice isn't what others feel. But there you go.
Thanks, Peter. So I imagine, to be honest, given the amount that's being fined here and the fact that Uber have already said that they're going to appeal, that we will be covering the story again at some stage, but potentially maybe wait a few months, because as we all know, this sort of thing does not move very quickly. But moving on to our next story, we are looking at Pavel Durov, the founder of Telegram. And initially, even this morning, he is under investigation. But now, as we were starting to record this, he has now been charged. So, in case you don't know, Pavel Durov is the founder and CEO of the messaging app Telegram, and he's been placed under formal investigation and been charged in France as part of a probe into organised crime on the messaging app. When we say organised crime, we're looking at money laundering and child pornography issues there.
Don't leave out the drug trafficking.
I'm sorry, yes, and the drug trafficking. And so, yeah, this is quite an interesting one, because he is actually the CEO of Telegram, which obviously we've not seen kind of one of the heads of social media platforms being arrested directly before. So this is quite an interesting one.
It is, and it's indicative of the approach now being taken when it comes to enforcement by Europe and leading EU states. The point here is that it's not like they're saying that he personally has engaged in child pornography, drug trafficking, or money laundering. They're saying that his platform is being used to facilitate these activities, and that French law enforcement agencies are trying to identify criminals who are using the platform to facilitate and commission these offences. And they're therefore saying that he should be personally liable for this when the platform has failed, as far as French law enforcement is concerned, to have properly assisted and responded to requests for information from French law enforcement. He has been granted bail, so he's out on €5 million bail, told that he can't leave France and has to sign out of the police station twice a week. As you say, Amelia, this is similar to if you're under investigation in France, it actually means that you have been charged, which is what we would know it as in the UK. In the UK, we have this thing called release under investigation, whereby the police investigate, and once they've reached the point where they've investigated, they then decide if they're going to charge you or not. In France, it's the other way around. They'll charge you and then work out if you did it. Seemingly.
Interesting.
I'm not a French qualified lawyer. That's based on my reading of a few things this morning. It may be entirely untrue, but that seems to be, in broad brush, the position here, and therefore it's an interesting position on it. I mean, for example, Elon Musk flies into France tomorrow, which is unlikely given the exchange he had with Thierry Breton, the French Commissioner of the European Union, in advance of the debate with Donald Trump that he hosted on X a couple of weeks back, where he was told by the Commissioner, you do not spread hate and disinformation on your platform, to which Musk said, I'll do what I want on my US-based platform, thank you very much. Because there is a different approach on this. America, and in particular American libertarians like Elon Musk, don't get the fact that there are different laws in place in other countries when it comes to what can or can't be said on certain issues. There is no constitutional right to freedom of speech sort of baked into a constitution in many other countries, quite in the way that it is in America. So the point here is that this chap has been arrested. This investigation will now go on. This could go on for months, yes. And it's going to be a big, complex piece of investigation, I'm sure, because there'll be a lot of evidence that they'll want to collect. But the point is that they're saying that, look, your platform is being used to very often facilitate things by organized crime gangs. And we feel that you are failing to cooperate in the fight of law enforcement against serious organized crime. Interestingly, the Kremlin has been swift to make a point here saying that France, that this shouldn't become a political persecution by France of a Russian entrepreneur, even though this chap has been living and operating outside of Russia due to having fallen out with the regime in Russia in the past. The Kremlin still hasn't lost the opportunity to do a little bit of political point scoring here. So it'll be interesting to see what happens on this. Apparently, Elon Musk is already pushing the hashtag Free Pavel movement on X. This is also, I think, a bit of an embarrassment to President Macron. He actually had met with this chap, Durov, previously back in 2018. He met with him several times, saying, why don't you have the HQ of your wonderful tech platform in France? We're a really great place for tech and for tech regulation. And obviously he refused, though interestingly they think that having flown in on his private jet on this occasion, that he might have been also due to meet President Macron for an agreeable meal at some point. And obviously that's not now happening because his own law enforcement agencies have arrested him.
It'll be really interesting to see where this goes, and it does continue to keep unfolding, as we speak. But I really do think I'm kind of want to know what precedent it's actually going to set, because it could be quite worrying for the likes of Elon Musk if this is where it's going to go.
Well, it comes down to this point around content moderation.
And that's under the Digital Services Act.
It is. I mean, this arrest is over the fact that the platform has not complied with requests from law enforcement. But more broadly, Europe, under the Digital Services Act, has got a real issue with regards to the content that is being hosted on platforms. Hence, what Thierry Breton was saying to Elon Musk. Hence, some of the enforcement already being made on the EU Digital Services Act and coming down heavily on the potential use of the platform for the commissioning of organised crime ties into the regulatory approach overall of the European Union when it comes to the content being hosted on these large platforms, which unfortunately by definition are American and largely Californian in nature. So we've still got this sort of rock and immovable object position between increasingly heavy-handed regulation of tech in Europe and the majority of that tech being owned and operated from outside of Europe in the US. I would just flag up at this point that if we think enforcement of the Digital Markets Act and Digital Services Act is strict, let's wait and see what happens when it comes to the EU AI Act.
Excited for that one.
Because there are quite swinging regulatory powers that Europe has given itself there in relation to AI. That is already being seen as a massive break on the use of technology and technological innovation in Europe, and could mean that we'll only see an even more larger gulf emerging between Europe and US and potentially China, who will forge ahead with their use and adoption of AI-based technology, and their economies will become more and more grounded on the use of AI technology, while Europe may not adopt and use technology in the same way. And given some of the innovations that have already been talked about happening in the 2030s, you have to ask, will Europe be able to sort of stay even up to speed as a consumer of some of those technologies if this regulatory wall around Europe operates in the way that it is at the moment? We could end up very much with a sort of two-tier economy between what's happening in Europe and what's happening elsewhere in the world. And the question then for countries like the UK is how far aligned do you wish to be with Europe? Are you going to align more with Europe, or are you going to align more with the more tech-based economies elsewhere?
Thanks, Peter. So moving on to our next story, we are looking at the Australian right to disconnect. So right to disconnect rule has come into effect in Australia, offering relief to people who feel forced to take calls or read messages from employers after they finish their day's work. New law allows employees to ignore communications after hours if they choose to, without fear of being punished by their bosses. A survey published last year estimated that Australians worked on average 281 hours of unpaid overtime annually. And this story kind of falls in line with more than 20 other countries, mainly in Europe and Latin America, that have similar rules in relation to contact after hours. I will note, however, that the law does not ban employers from contacting work after hours. Instead, it gives staff the right to not reply unless their refusal is deemed unreasonable. So, under the rules, employers and employees should try to resolve disputes among themselves, and if that is unsuccessful in finding a resolution, Australia's Fair Work Commission can then step in. So this is fairly interesting here because there seems to be somewhat of a broad brush here, specifically if you look at the word deemed unreasonable. So Peter, I will pass over to you here.
So this is, as the article suggests, this isn't the first country to adopt these sorts of rules. However, it's probably one of the larger economies to have turned around and taken this step. Though it is likely, I think, that we'll be getting something similar in the UK before too long. The new Labour government is looking at various rules around employee rights, and this is likely to be one of the things that is probably low-hanging fruit. It's easier to introduce.
I mean, I can see why it would track as well, given, you now have a level of people that are working from home as a result of the pandemic, and therefore the difference between work-life balance is probably significantly more blurred than perhaps it was pre-pandemic.
Yeah.
And then if you're then continuing, if you've got a home office and continuing past your normal working hours, I think, that's fine. And it probably might help in terms of that, but it is certainly interesting.
And it seems to be something that, from a sort of electoral perspective, it's fairly popular.
Yeah.
It's easy to introduce comparatively. And let's face it, for the majority of staff, for the majority of businesses, sometimes you do get this sort of culture of always being on and always having to reply to emails. I almost feel, though, that this element of regulation coming in is not. It's almost coming after the time it was most needed.
Yeah.
I said something like this really was needed before and or during the pandemic.
Yeah.
Now I think it's already becoming quite popular I'm hearing some entrepreneurs saying this, that, actually, that they recommend not having, as well as sort of not having social media on the phone, or sometimes say not having emails on your phone. If you need to do work, log into it on your device, but don't have it so it's set up and you're getting a ping, ping, ping on your device. If you are, otherwise at home with your family, out with family friends, that sort of thing, or on holiday, then you shouldn't really have that thing set up on your device anyway. And indeed, it's something that I do. I don't have an email app on any of my devices. If I want to access email, I can do so, and then I can stop. I know people across the legal profession. I know several judges who do this, who say, right, that's it, I'm going away. I take the app off my phone. Because it's important to have that disconnect.
It's interesting that on the flip side, though, if you have then got maybe, for example, I know that some people commented specifically from the financial industry, wherein they get paid a lot of money to be on call essentially 24/7. And there is that level of, okay, well, how does that work in terms of this new law? If you're contracted almost to be available 24/7, does that not give you a leg to stand on with this right?
Well, I think this will instead lead to probably express provisions in some employee contracts.
Yeah.
In the same way that, for example, you had, I think, the 35-hour minimum working week adopted in Europe, but then some countries had an opt-out. So certainly it's one of the things that in the legal profession, one of the first things that you notice in your employment contract is that there used to be an opt-out saying, oh, just for the purposes of your job, European Working Time Directive doesn't apply to you, matey. So good, I'll be getting those long hours. Fantastic. It'll be interesting to see if in certain professions and industries there is that sort of specific carve out.
Exactly.
When this sort of legislation is introduced, does it allow for those carve outs, or does it say no, on a blanket basis you are not able to require people to do this? Or in this instance, as we see with the Australian legislation, there seems to be a very large carve out in terms of, well, what is or is not unreasonable.
Yeah, I think that's probably going to be the sticking point in terms of unreasonable, what is and is not reasonable. And I wonder whether there'll be more of a kind of different approach dependent on the industry you're in.
Yeah.
For example, if you are talking legal services or highly regulated service, there might be somewhat different standards as to what is deemed unreasonable to maybe if you are simply doing something that's more kind of working in a shop or something like that. But it certainly is going to be interesting to see whether it takes, and also whether the UK will adopt something similar.
Yeah, I mean, I can imagine a lot of industries, anything from, say, construction, where you've got just-in-time deliveries and things having to turn up within 24 hours, and if something doesn't turn up, then work can't happen that day. I mean, that obviously leads to people in charge of the logistics on that having to work very long hours, sometimes with those in different time zones. You can imagine in the field of medicine, if you've got
an unreasonable page an hour after your shift, what are you going to do? There's almost a moral and ethical point there. Like, well, do you respond? Do you not respond?
If you're a consultant or you're a specialist nurse on a team that handles cancer treatment and some results come through from a lab, and it might be outside of your office hours, you're still going to want to look at that and see what the thing is, and does your patient need help, and do you need to notify that patient, do you need to book someone? So I can see a lot of examples here where for a lot, dare I say potentially the majority of people, you could apply this fairly easily. I think there are an awful lot of sectors where it's a lot more problematic to do it, just due to the nature of the job. And I think actually it could be, you're almost saying that there'd have to be so many checks and balances built in that you can almost imagine employees just saying, you know what, I'm not bothered. Because of the nature of the role, we're going to carry on doing this the way that we have done, because we would, literally in some instances, it can be life and death. Yeah,
I think it's going to be very much a subjective right, like you say, because of the different sectors that it could be applied to. And I mean, as well, like you might get a text from a colleague on a Friday night saying, do you mind picking up some milk on Monday, because you just forgotten. Something as simple as that, Because I know between myself and a colleague, we'll be like, oh, someone needs to pick up the milk in the morning. Normally if you respond, it's probably unreasonable to not respond, but nonetheless, something simple and easy.
Yeah. But then, I mean, even in our industry, what if it's that Friday evening when you find out that if one of our important clients, if they suddenly found they were a victim of a cyber attack, we'd be all hands to the pump trying to help that client. And it doesn't matter if it's, say, 8 o'clock on a Friday evening, it's a bank holiday weekend. No. We'd be still wanting to try and do the best that we could to help that client. It would probably be at that point having a fairly painful experience. You'd be wanting to provide them with the best support possible. And the argument of, I'm sorry, we can't, it's outside of our work hour, that
not really going to fly.
It's not really going to cut it, is it?
No. So I definitely think that's quite an interesting one. And we'd probably go on and on about the different checks and balances that would have to be applied. But
yes.
For now, we'll leave it at that.
Yeah.
So moving on to our next story, we are looking at ICO action against the Labour Party. So the ICO have issued a reprimand to the Labour Party for repeatedly failing to respond to people who ask what personal information the party held on them. This is known as the subject access request. So in November 2022, the Labour Party received 352 subject access requests that required a response. Of that number, 78% had not received a response within the maximum compulsory time limit of 3 months, and over half were significantly delayed by over 1 year. So the backlog of SARS developed following a cyber attack on the Labour Party in October 2021, which led to an increase in requests from the public. So the ICO investigation followed over 150 complaints regarding the Labour Party's handling of SARS in the year from November 2021 to November 2022. This is quite a bad failing by the Labour Party here, especially now that they are actually in government. Doesn't really scream confidence and reliability, does it?
No, albeit though that the period in question relates to the period November 21 to November 22, so when they were in opposition We aren't talking here about the period during the pandemic either. So, lockdown restrictions were something that had already been lifted by November of 21. So it's not as though you can sort of hide behind that as a reason why there could be problems. It's though, and of course, this embarrassingly for the Prime Minister, this does occur during the period that Keir Starmer was, and indeed still is, leader of the Labour Party. During this period, you've also got to put it in context. So there could be a lot of during this period, a lot of claims were made by Labour staff in relation to employment rights, in relation to wider issues with regards to a finding against the party by the I think it was the Human Rights Commission at the time. I'm not going to go into the ins and outs of that. Just to say that during this period, there were clear reasons why the Labour Party would have been receiving a lot of subject access requests. The main tool that an individual has in order to be able to turn around to an organisation and say, what have you been doing with my personal data and how is it being processed, etc. So the fact that it wasn't responding to those is not ideal for it. Now, the wider point here is that, unfortunately, once they started to investigate, it was found that there was a privacy inbox at the Labour Party which wasn't being checked, and therefore it had about 600 subject access requests, and they'd just been left in there. Now, this is a bit of an object lesson in if you're going to set up a particular email inbox that could be receiving requests like this, or requests under the right to erasure, or requests under any of the other numerous data subject rights created by General Data Protection Regulation, but baked into UK law currently under the UK Data Protection Act 2018, make sure you're checking it.
And I think that's something that, as well, that's actually been brought up with our clients recently, wherein they have not quite gone live yet with what they're hoping to do. And we've been really saying very clearly that, look, if you are going to be doing this, you need a clear place where people can exercise their rights. And most importantly, you're going to have to make sure that they're being taken seriously. And actually, you're looking at it, you're reviewing it, and they're being dealt with correctly.
So one of the first things we say when we're actually drafting privacy policies for our clients is, first of all, with each of those rights, you make it, even if there's an element of duplication in what's being said, you make it very clear to the reader how they can exercise that right, usually by submitting an email. And we then say to the client, is there a specific email you want us to use? Is it, an inquiry at or privacy at or whatever it is? It's being put in this policy, and we then strongly suggest that you are regularly checking or have that inbox. That it is the role and responsibility of an individual to be checking that inbox.
And why is it important to check? That's because there are very specific rules and timelines in terms of how you have to respond to, for example, a subject access request. You have, I believe it's 30 calendar days to make sure, as a minimum, that you go back to that individual who is making the requests. Under certain circumstances, you can extend that to, I believe it's an additional 2 months. I might be wrong there, Peter. Is that correct?
Well, yes, even then, with if between a data subject and an organisation, if they wish to play ball, if they basically say, look, we're overwhelmed or we can't do it, we are getting to you, we will help you. Very often, you'll find a data subject will be understanding, as long as you don't push it, for months or indeed years. The issue here, though, is that even though it looks like the Labour Party, once they knew they'd made this mistake and they devoted people to try and clear the backlog, it's still, they've still ended up facing this enforcement from the ICO. The enforcement, we should point out, is the ICO's favourite tool. It's a reprimand.
There we go.
So it's not a fine, but a reprimand, not possible to appeal it. I'll be interested to see if on the back of this, if the government then says, what's that? What are you doing? Why are you enforcing in this way? We didn't know that enforcement was these reprimands rather than fines. Does it lead to that conversation at the heart of government? I almost get the impression that the ICO has been using these things because he can, and that no one's really...
And that the fact that there's limited understanding elsewhere about what they mean.
Yeah, and no one's really crossed the nettle of going, oh, are you doing that? And, oh, you can't appeal it. I mean, if the Labour Party does that, how do we appeal this? And, oh, we can't.
It's
Oh,
a
that's
rude
not
way
very
to
good.
do that one.
Yeah, so you never know. This could be the moment that the ICO's fun in using reprimands for his own general fun and amusement. It may mean that may come to an end, or more likely, hopefully that Labour will look and think, well, maybe actually using a tool, an enforcement tool that is more clearly recognised within the enforcement matrix, may be more appropriate.
Yeah.
So we'll see what happens on that. But in the meantime, yeah, it's just massively embarrassing for the party that's just entered government.
Exactly. Moving on to our next story, which is actually continuing with the ICO. So the ICO have submitted a provisional fine for a software provider after the NHS ransomware attack. So the ICO have provisionally decided to fine Advanced Computer Software Group Ltd. just over £6 million, following an initial finding that the provider failed to implement measures to protect the personal information of almost 83,000 people, including some sensitive personal information. And I will just highlight that this is a provisional fine, and the Commissioner has pointed out that no conclusion should be drawn at this stage that there has in fact been any breach of data protection law or penalty imposed. It's just that they're considering the representation that the Advanced could make before a final decision, where the amount could change. So I will just kind of caveat that a bit. But in this provision, Advanced have been fined 6 million. And you might ask, well, why is this important? And this is to do with the supply chain. And when you are looking at implementing service providers within your business, because actually they can be just as liable as you are in terms of if there is a breach. And I think you do have to be incredibly reticent of the fact that actually you need to be checking any service providers that you have and ensuring that you do complete the necessary due diligence based on your specific circumstances, because one service provider might be fined for one organisation, but that does not mean that same different organisation could come to the same conclusion, because you will be processing different levels of data. It might be more sensitive personal data, it might be more of your bog standard personal data, but that is a key difference. So Peter, I will pass over to you.
Indeed. So I think one of the key things to bear in mind with this is that this was a ransomware attack. We have in the past had some individuals contact us who've said, they've either been, using a provider that says we've had a ransomware attack, but it's all right, nothing happened, we aren't going to report it, and it's all perfectly safe now. And you sometimes question the wisdom of that. In this instance, it was a ransomware attack, but it was found that hackers had accessed a number of Advanced Healthcare's systems via a customer account that did not have the appropriate multi-factor authentication on it, and that led to the clear exfiltration of almost 83,000 personal data records following this attack.
I think the interesting thing here as well, I do want to point out, is the data exfiltrated, including phone numbers, medical records, as well as details of how to gain entry to the homes of 890 people who are receiving care at home. So you could literally walk up to a vulnerable person's house and gain entry, which is very, very poor.
And that's the reason why the fine is the size that it is, even though this is a supplier rather than some of the big multinationals or big government agencies that usually come in for enforcement from data protection regulators, and the amount of people affected isn't in the millions or the tens of millions, which very often is the case. It's the fact that we've got 82,000 people, but some of it we're looking at people who are very vulnerable, and we're looking at information that is, when it comes to things like medical records, very sensitive. So it's for that reason that I think the fine is for as much as it is. And some people might say, well, 6 million. Again, it's not the 250 million that Uber's just faced. Well, no, but for a company like Advanced here, that 6 million could probably wipe out their profit for a year or two. Quite
exactly. And again, I will just flag that at this stage, that fine amount is subject to change.
Yes.
But this is how it stands at the moment.
Yeah.
Moving on to our final story of the podcast, we are looking at the prisoner's mobile phone access. So, an Albanian murderer is flouting the law by sharing videos and posting on his social media accounts from his cell in a Manchester prison, even though the guards repeatedly confiscate his smartphones. So this is quite interesting, the fact that obviously this guy is in prison. He's sentenced to serve 32 years in jail after being convicted of killing a drug dealer. And the prison staff have seized at least 3 phones in the past 4 months, but he still has regular access to them. So it is a criminal offence to possess or use a mobile phone in prison without authorisation, but prosecutions are rare. So there's quite a bit to unpack in terms of this.
Yes, interesting that each time this guy, a phone's taken off him, he gets another one, and then he starts opening up accounts, because the majority of phones are smartphones, so he can then open a new TikTok account. He apparently had 60,000 followers on a TikTok account before it was again most recently taken down. Really, he's actually posting clips. He's broadcasting live videos, live feed from within one of His Majesty's prisons. He's taking, as usual people do on social media, you record yourself singing along to music. It's not great. This, unfortunately, then, of course, will be taken totally out of context by those who wish to say, well, look, this shows that prisoners are they're watching TV. This guy's sat there wearing designer T-shirts and shorts, and he's sat there using a phone, and he's having a lovely time. This isn't exactly, crime and punishment, is it? Which doesn't help. He's sat there using a PlayStation console. He's got his books. Apparently, he's reading the Albanian edition of Jeffrey Archer's Cain and Abel, as well as playing chess and doing various things, and also chatting to women in TikTok Live, an interactive game. So there you go. So the fact then that, as we say, it is clearly the case that he shouldn't have a phone. He should not be able to use social media. He shouldn't be able to actively do this stuff. Unfortunately, as well, of course, on large social networks, the minute you start to get tens of thousands of followers and have very popular content, you start getting paid for it. And there are rules about prisoners profiting from their time in prison. So, for example, a convict can't write a book and sell that while they are in prison. After they're out of prison, different matter. But if it's like, congratulations, you're in prison for 30 years, having killed someone, as this chap is, the whole point is that you can't then, while you're in prison, profit from telling the story of the crime that you're in prison for.
It does raise kind of questions as well in terms of the fact that obviously these things are getting into prison, and how are they getting there? I know that, Peter, we discussed the fact that in some instances drones are now being quite regularly used in terms of transporting things into prisons more undetected than before. You've got cases where drugs, etc., being transported in mobile phones. Yeah. And it is that level of how the technology has advanced enough to then kind of get around existing rules in terms of prison security.
Indeed, unfortunately, it is the case that for decades there's been problems with drugs and mobile phones finding their way into prisons, and indeed being fairly ubiquitous in prisons. That isn't the news story here. The news story is the fact that it's the sheer volume of them.
Yeah.
In fact, he's had multiple phones, and then he's using them on social media and being able to communicate freely, not just with, for example, speaking to his...
speaking to his partner, significant other, family, etc.
Well, the worry is when someone's still continuing to run an organised crime gang from prison.
That's
great. And that would be the main concern, but it's showing that the concern isn't now not just that, it's the fact that they can have a popular profile outside.
It brings prison pen pal into a whole new light.
Yeah.
But,
yeah. So, and then it's the element of how is this supplied. So classically, it always used to be, people, visitors attending could potentially be bringing illicit substances in and passing them to prisoners. But now it's the fact that, or even things being thrown over the fence where prisoners are exercising. That's been the case for decades. Now, apparently, it's things being attached to drones and the drone being flown in.
how times have changed.
It just shows, so yes, as the technology improves, so the method of delivery changes. But it's the fact that it seems to be happening with a level of impunity. And this then can take us into a wider conversation around the figures in terms of the number of convicts in the UK, the fact that unfortunately we are having to let more out so that we can convict more, in particular since the recent riots in the UK. The fact there's been a consistent lack of funding of the justice system, so the prisons, the courts, the people operating and working in the prisons and the courts have not had any sizable funding apart from a brief bump they were given during the pandemic for decades. And this is just therefore leading to, surprise, surprise, a lack of security and a lack of policing within prisons, which is leading to conditions like this. But that's a conversation around the justice system, I think, for another day. I think we're out of time now.
Yeah. So that was our last discussion of the episode. And if you do have any questions about anything that we've spoken about today, please email us at admin@digitallawuk.com. Summary of today's stories are available on our website, as well as the links to the original stories containing more information. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. Big thank you again to Answer and Evaluate for helping to produce this podcast. And if you'd be interested to hear more about Answer and Evaluate services, please take a look at their website you can find at www.answerandevaluate.com. Just a reminder, these episodes are available on our website, YouTube channel, and podcast channels such as Spotify, Apple Music, Amazon, and essentially anywhere you can get your podcasts. Thank you for listening, and we hope to see you again next week.